Okay, folks, of course, on the eve of Christmas Eve, we got breaking news from the Supreme Court of the United States. We've been waiting for this decision to come out. Today was actually technically the last day that the Supreme Court could issue opinions before taking, quote, like holiday recess. This is the state of Illinois, Governor J.B. Pritzker, and the state of Chicago. They sued the Trump administration specifically because convicted felon Donald Trump federalized the National Guard and deployed those troops to the city of Chicago. We have seen the footage time and time again about how the National Guard has been used in those cities. We've seen what's been happening under the guise of immigration enforcement. We've been looking at places like Broadview Detention Facility and the way that protesters just exercising their First Amendment rights to assemble and to protest and to exercise their right to free speech, how they've been treated. I interviewed Pastor David Black, for example. He's a member of the clergy, how he was, nailed and hit in the head and the body with these pepper bullets, and there's been tear gas canisters deployed and rubber bullets. I mean, it's been horrible. And to not waste any more time, I'm letting you know that right now, the Supreme Court of the United States in a 6-3 decision, and you'll be interested in hearing who the split was on the 6-3, they have denied the Trump administration's emergency application for a stay, meaning they have denied the Trump administration's ask for a district court order that was entered in federal court in Illinois for that order to be paused. The Supreme Court saying, we are not going to touch this emergency application for a stay. So let's get into it. Now, I've got the order here. We're going to walk through it, and I'm going to let you know what the holding was from the Supreme Court so you understand, and then we're going to get into the background so you know how it got here in the first place. On October 4th of 2025, Trump called up 300 members of the Illinois National Guard into active federal service under the lie, I'm going to say it was a lie, to protect federal personnel and property in Illinois, particularly in and around Chicago. The following day, on October 5th, members of the Texas National Guard were also federalized and sent to Chicago. In calling forth the Guard, Trump relied on a specific federal statute, 10 U.S.C. Section 12406, 12406, subsection 3. If that subsection sounds familiar, folks, it's because it was used in where? California and in Oregon and in places like that to be able to federalize and deploy the National Guard. Now, Trump said that particular subsection of that federal statute allows him to federalize members of the National Guard if he is unable with the regular forces to execute the laws of the United States, end quote. Now, remember that phrase, people, because that ends up being relevant to how the Supreme Court ended up deciding this particular issue of the application for a stay. A federal judge in the United States District Court of the Northern District of Illinois entered a temporary restraining order that barred the federalization and deployment of the National Guard in Illinois. In other words, a federal judge found that Donald Trump could not federalize the National Guard and deploy them in Illinois. The Seventh Circuit Court of Appeals denied the Trump administration's motion for a stay, allowing the National Guard to remain federalized, but saying that they could not be deployed. In other words, an appellate court, a federal appeals court, said that trial court judge made the right decision when it came to not deploying the National Guard, but said, you know what, we're going to allow the fact that Trump federalized them, meaning like he activated them, that we're going to allow Trump that. But we're not going to allow Trump to actually utilize them or deploy the National Guard in Illinois. Then the Trump administration raced, as it does, on these emergency applications that you and I have talked about a lot here at the Katie Phang News Channel, like a kid running behind mama's skirts. The Trump administration raced to the Supreme Court saying, hey, we want you, Supreme Court, to tell that federal judge in Illinois that she made a mistake. That not only can Trump federalize, activate that National Guard, right? But that he can actually deploy them to be used in Illinois. Now, let's get into a little bit of some specifics here because I think it's important for you to know. The federal judge who barred the Trump administration from federalizing and deploying the National Guard actually took evidence and heard evidence about the state of affairs in Illinois. And that particular federal judge, her name is April Perry, back on October 9th, when she issued that temporary restraining order, she said that the Trump administration had made no attempt to rely on the regular forces before it federalized the National Guard. In addition, the Trump administration had failed to basically prove that the conditions in Illinois merited or warranted being able to deploy the National Guard. And as I said, the Seventh Circuit Court of Appeals agreed with Judge Perry, saying you cannot deploy the National Guard in Chicago. Then, just a few days later, on October 17th, that's when the Trump administration raced to Supreme Court to say, hey, you need to get involved here, and you need to basically put that district court's order on hold. Now, what did SCOTUS do? SCOTUS asked both sides to basically do additional briefing, to file additional legal documents to explain how they were defining what regular forces are. That's why I told you to pay attention to that phrase. Quote, the president is unable with the regular forces to execute the laws of the United States. The Supreme Court said, I want to know, what's your position on how do you define the phrase regular forces? And in the end, the Supreme Court of the United States, in a 6-3 decision that just got issued today, said the following. We conclude that the term regular forces in that subsection 12406, that federal statute, regular forces likely refers to the regular forces of the United States military. The interpretation means that to call the National Guard into active federal service under 12406 sub 3, the president must be unable with the regular military to execute the laws of the United States. Because the statute requires an assessment of the military's ability to execute the laws, it likely applies only where the military could legally execute the laws. Such circumstances are exceptional. Under the Posse Comitatus Act, the military is prohibited from executing the laws except in cases and under circumstances expressly authorized by the Constitution or Act of Congress. So before Trump can federalize the National Guard under 12406 sub 3, he likely must have statutory or constitutional authority to execute the laws with the regular military, and he must be unable to do that function with the military. Have we had some type of congressional authorization for Trump to deploy the National Guard to Chicago? No. At this preliminary stage, the government has failed to identify a source of authority that would allow the military to execute the laws in Illinois. The president has not invoked a statute that provides an exception to the Posse Comitatus Act. Instead, he's just relying on his inherent constitutional authority that, according to the government, allows him to use the military to protect federal personnel and property. Because the government didn't carry its burden to show how that federal statute allows Trump to federalize the Guard in his exercise of his inherent authority to protect federal personnel and property in Illinois, we need not, nor will we address the findings made by Trump under that federal statute, denying the stay. Now, here's, again, where it's interesting. Do you know who joined in on this unsigned SCOTUS opinion? Brett Kavanaugh. Brett Kavanaugh joined alongside Sotomayor, Kagan, Jackson, right? Which is pretty remarkable. Kavanaugh actually wrote his own concurrence, and this is what he complained about. He actually said that this unsigned majority opinion went a little too far in its analysis, and it should have actually stopped with just the definition of what regular forces is. So Kavanaugh says, I'm going to deny the governor's application for a stay, but I don't think we should decide more because I think it's a problem. Now, let's go a little bit farther along. Let's get to the dissent, because the hypocrisy is rich, as it often is with the conservative justices on the Supreme Court. Justice Alito and Justice Thomas joined together in a dissent. And in their dissent, what they're bitching about is this. They're saying that because the state of Illinois and the city of Chicago took a position about the definition of regular forces on the underlying kind of levels of the appellate court, that they should not now be allowed to argue that the regular forces means the military. So this is what it says. They're saying that the Supreme Court's majority that decided this denial of an application for a stay basically raised an argument that had been waived below by the state of Illinois and the city of Chicago, and now rules in their favor. The court also reaches out and expresses tentative views on other highly important issues on which there's no relevant judicial precedent and on which we have received a scant briefing and no oral argument. End quote. We got to talk for a second, guys. Because as you know, there have been several applications on an emergency basis on the shadow docket to the Supreme Court of the United States by the Trump administration. And the Trump administration has prevailed time and time again, much to our consternation, irritation, and frankly, much to the unconstitutional results. And what's wild to me is, oftentimes when these emergency applications are made to the Supreme Court of the United States, there is no fully developed record, meaning there is kind of this preliminary kind of findings or preliminary things that have happened. But there's really no full and complete record that the Supreme Court is considering. Why? Because these are emergency applications. These are pretty early on in the litigation. So for Justices Alito and Thomas to be complaining in their dissent that there is scant briefing and no oral argument is fucking rich. Pardon my French. So both Alito in his dissent, to which Thomas joins, says, I'm not prepared to express a definitive view on certain questions because I have serious doubts about the correctness of the court's views. I strongly disagree with the manner in which the court has disposed of this application. In the lower courts, the parties agreed that the phrase regular forces meant civilian federal law enforcement officers, not the military. And then later on, as I said, the state of Illinois and the state of Chicago said actually regular forces means the military, and the dissent is taking issue with that. Then the dissent goes on to further, give a helping hand to convicted felon Donald Trump, because they're saying that the district court erred in refusing to afford deference to Trump's determination that calling up the National Guard was needed to execute federal law. Now, here's the thing. The dissent is ignoring the fact that the reality of the circumstances, the factual conditions on the ground in Chicago, in Illinois, do not justify or merit or warrant the deployment of the National Guard, just like other federal judges in places like Portland and in LA have found that the facts and circumstances on the ground in real time do not merit, justify, or warrant the deployment of the National Guard. But the Supreme Court's dissent in Alito and in Thomas, they would just ignore that, right? They would basically say, I'm not going to listen to the district court's findings because to hell with them. Why? Because they don't agree with how the district court made these findings. And then, of course, Alito and Thomas go on to blow up this idea that ICE in around Chicago has been the, quote, target of unprecedented sabotage and violence since June of this year, end quote. I don't know about you, but all the footage I've seen is ICE brutally trying to beat up protesters and brutally trying to beat up demonstrators that have been there in Chicago. And again, the dissent wants to ignore the district court's findings about the credibility of witnesses that have teed up declarations that the Trump administration wanted to rely upon to talk about how fucking crazy things are in Chicago and why Trump has no alternative but to activate, federalize, and deploy the National Guard. They go on, blah, blah, blah. There's also a second dissenting opinion that was written solely by Justice Gorsuch, and he kind of whiffs on this himself a little bit. He says, in the present posture, I'm not comfortable venturing an answer to any of the questions that he poses himself. The court has never decided a case about the meaning of Section 12406 sub 3. True. Let alone explored its interaction with other statutes in the field or the Constitution. Nor do we have much help on many of these matters from the parties' briefs before us. Understandably given that this case comes to us in an interlocutory posture on a highly compressed schedule. In other words, yeah, because the Trump administration hauled ass to get an emergency application, there's a reason why you don't have a fully developed record. Under these circumstances, Gorsuch says, caution seems to be key. I would decide this application narrowly based only on the few arguments the parties have preserved and the evidentiary record as it stands. So Gorsuch would also disagree with the majority. Look, folks, I don't care how we got there, but we got there. And this is one of the first and few times that the Supreme Court of the United States has basically, one, told the Trump administration, we're not taking your emergency application for stay. And two, has basically said, we are not going to countenance giving the executive branch as held in convicted felon Donald Trump. We're not going to let Trump basically exercise an emboldened kind of, forcing of his powers in the executive branch over the judiciary in terms of being able to just create out of whole cloth and fabricate out of whole cloth a factual scenario that he, as in Trump, thinks merits deploying the National Guard. This is a victory, people, for the rule of law. It's also a victory because we've now seen the Trump administration back off in LA. As I spoke to California Attorney General Rob Bonta for the first time in 6 months, we're not going to have the National Guard or those troops in the streets of LA. And we've also seen judges in places like Portland, as I mentioned, standing up to the Trump administration saying, not in Portland, because there is certainly nothing going on here that merits having the National Guard. Thank you for sticking it out with me. Again, on the eve of Christmas Eve, we get this decision, and it's not surprising because the Supreme Court wanted to leave for its holiday break. But I think it's an important thing that we break down together. Be mad, be outraged. If you haven't subscribed, like and subscribe, please. I would appreciate the support, and I'll see you guys on the other side. My following guest says courage is contagious. And if there's somebody who knows about courage, it's her. Maine's Secretary of State, Shenna Bellows, not only has been doing an exemplary job delivering for all of the people of Maine, but she's also running to be the next governor of that great state. I thought it was important to go back in time a little bit with Secretary Bellows to talk about her act of courage when she disqualified Donald Trump from the Republican primary ballot in Maine as a result of his involvement in the January 6th insurrection. And also talk about why it's so important for us to lean into our lived experiences to be able to make us better elected officials. Take a listen to my conversation with Secretary of State Shenna Bellows. And joining me now at the Katie Phang News Channel is the current Secretary of State Shenna Bellows for the great state of Maine, who's also, I know, going to be the next governor of the state of Maine. But Secretary Bellows, thank you so much for taking the time to join us today. I really appreciate it.
It's a real pleasure. I love being on your shows.
So let's start with the following, because for me, my personal kind of connection with you is still professional, but I was still at MSNBC and I was covering the news, the breaking news, when you disqualified then candidate Donald Trump from the Maine Republican primary ballot back in December of 2023, pursuant to Section 3 of the 14th Amendment, the insurrection clause. And for those of you that may or may not remember it, I'm just going to refresh everybody's recollection before we move forward. It says that no person shall be, and we'll say president, we'll skip forward and say president, or hold any office under the United States or under any state who, having previously taken an oath to support the Constitution, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. That's a direct quote to the Constitution. I know that you were following suit after Colorado had done the same, but I really did laud not only the creativity, but also, frankly, the courage to be able to do that, because this Section 3 movement, frankly, hasn't gone away. And there are a lot of us that still believe that that in and of itself should have been a disqualification. But can you kind of give us some inside baseball on what that was like to decide to do that, especially how politically charged the climate not only was then back then, but remains?
Absolutely. And first and foremost, Maine is a unique state. Like, we pride ourselves on our independence, our lobster, LL Bean. And we had a law that no other state in the country had, and that is to require the Secretary of State to ensure that every candidate meet the qualifications of the office they seek. So, and in the law, there's this citizens complaint process where citizens can challenge the qualifications of a candidate running and force the secretary to hold a hearing, to serve as a judge with both parties represented by attorneys, and then to issue a decision. And there are tight timelines in Maine law. That hearing has to be within 5 days, the decision within a week. Now, I had done those hearings before on pretty small potatoes races in Maine, right? So it wasn't unprecedented. But when citizens brought a complaint about Donald Trump's qualifications because of his incitement of January 6th, I had to have the biggest profile hearing of my career prior to. I mean, we're an independent state. We're also a fairly small state. And so, attorneys were represented on both sides. They presented the evidence. I reviewed hundreds of pages of documents, reviewed the videos from January 6th, reviewed Donald Trump's speeches at the time, his tweets. Remember, he was calling people to the Capitol for January 6th, and he was challenging the election results that he still challenges because he's such a sore loser, perhaps the nation's biggest loser. And so I heard all of the evidence. I took a week to deliberate on the evidence. Colorado happened prior to me issuing that decision. And at the end of the day, in good conscience and in accordance with the oath I swore to uphold the Constitution and the laws of the land, I determined that he was responsible. He engaged in insurrection on January 6th, and that was disqualifying. You just read the plain text of the Constitution. There was no prior precedent for a president engaging in that level of insurrection. So I issued my decision. And I remember talking to my husband the night before because he didn't know what I was going to do. And I said, look, I'm going to issue this decision tomorrow. I've talked to law enforcement and they're prepared for whatever happens, no matter what I do. And I knew that I could receive a lot of pushback, that it might be the end of my political career, that I would be threatened. I didn't quite anticipate the level of threats and everything that ensued.
Well, Secretary Bellows, I want to stay on this just for a minute or two longer because ultimately, to refresh people's recollection, the United States Supreme Court ended up deciding in the Colorado suit that made it there, Trump versus Anderson, that the states themselves cannot invoke the insurrection clause, that it actually is incumbent upon Congress to be able to take action when it comes to federal office holders or federal candidates. Now, I understand that there's nuances in the law. I've been a lawyer for several decades now. But what I really found to be frustrating about that decision was what you've just recited to the viewers, which is you thoughtfully conducted evidentiary hearings that took place wherein you actually had lawyers involved, the presentation of evidence, the hearing of arguments. And in Maine, you don't have to be a judge, let alone a lawyer to do it. It's a part of your job. So you were just doing your job as the Secretary of State, listening to the presentation of this and making a determination pursuant to the law that exists in your state. Because it's kind of ironic to me now because everything seems to be kicked back to the states now by the feds and by SCOTUS, right? But when you are exercising your independence in the state of Maine to make this decision for the constituents and for the people that are going to vote in Maine, somehow that's an overstep for you?
So the Supreme Court ruled against us, right? And the Supreme Court currently seems to be showing utter and complete deference to President Trump, throwing out decades, even centuries of legal precedents, and they seem to be completely in his pocket. Now, I swore an oath to uphold the Constitution, so when the Supreme Court said he shall be on the ballot, I adhered to that. But what I will say was really ugly is that Trump and his supporters across the nation, indeed internationally, targeted me and members of my family. So law enforcement advised us to seek a safe house. And I didn't share this on TV at the time. I didn't tell you or anyone else who was calling. I said we were away for the weekend, which was true, but we were away for the weekend and longer at the recommendation of law enforcement. And I can talk about it now because they found the person that swatted our home, generating a law enforcement fake call to law enforcement, trying to generate that SWAT team response, that potentially violent confrontation between the homeowner and law enforcement. They found the person, they prosecuted him, DOJ actually did, and they found him guilty. He pled guilty. So he faced the consequences of that. And, my husband and I feel perfectly safe. But that was really unacceptable. And I think we've seen it. We saw it throughout 2024. We've seen it into 2025. The deliberate incitement of threats and targeting the judges who dare to stand up to this administration. Members of Congress have talked about this, that they are scared. And then that really leaves the people questioning, who are you representing? Are you representing your own self, or are you representing the people? And I determined, I went to work every day while we were in that safe house, and I determined that I was going to do my job no matter what, even when it's hard, even when I was getting targeted and threatened. And I think, in this time when fear is so contagious and cruelty seems to be the point and hate is an ascendancy, we have to remember courage is contagious too. And we have to continue to do the right thing, even when it's hard.
Well, and you continue to do the right thing. So instead of being dissuaded or cowed into submission, not only have you continued to defend the rights of all people in Maine, let me make sure this is clear, regardless of party affiliation, you have done your job as the Secretary of State to make sure that the people of Maine are properly protected and represented. But now you actually want to go one step further and you want to be the governor of that state. I really wanted to mention this to the viewers, and I wanted to ask you if you would share a little bit more about this. I didn't know this until I was preparing to speak with you, but I did not know that you grew up in a log cabin in Maine and the daughter of a carpenter and a greenhouse worker that struggled to make ends meet, which is a story for a lot of American working families. But then you didn't have electricity or running water until you were in 5th grade. And the reason why I share this is not to garner sympathy, but to engender empathy, because you have a life and a lived experience that is unique to you, but has overlaps with so many people. And in the wake of the big bullshit bill from Trump and
that's a good name.
Republicans, that's what I've been calling it. And you don't have to take it, but that's what I think it is. In light of the wake of that, wherein a lot of people are feeling it, but not really going to feel it strategically because the Republicans staged a lot of the big negative parts of it to kick in post-2026 midterms. Talk about why that help frames who you are, your work ethic, your moral compass, and why you think it's important that Maine have somebody who's a governor who understands that things just don't come easy all the time to all people.
I'm so grateful for that childhood and for my parents, because I think they raised me to be Maine tough and kind and tough. And I say that because, I remember when my parents were first building our home, we lived in a tent that summer, and they were digging out a cellar hole virtually by hand with help, and then put a cap on it. And we lived in the basement that following winter. And the reason I have such a vivid memory of me, I was 4, my 3-year-old sister, my 2-year-old brother living in that basement is because, one night this hurricane came in, and I guess my parents didn't do the best job in making it watertight. So the water was coming in. So this is before cell phones, right? And so we drove up to about an hour to where my uncle lived. He wasn't home. His home was locked. So we had to drive somewhere else. It was another hour to where some friends lived, and that's where we spent the night. So the reason I believe in housing for all is because I understand firsthand how scary it is when you don't know where you're going to sleep at night. The reason I'm passionate about public education is because I entered kindergarten, still living in the basement with a lisp, and I had great teachers and free speech therapy. But for that, I wouldn't be Maine's first female Secretary of State. And the reason I believe in healthcare is, whether it was the basement or the kerosene lamps we used until I was in the 5th grade, I have pretty bad asthma. Might have been genetic luck of the draw. And so an emergency room has saved my life more than once when I was a kid. And my parents went without health insurance in these blue collar jobs their whole lives. My dad got health insurance for the first time as a self-employed carpenter when the Affordable Care Act passed. Wow. My mom She went back to school at age 49 and to become a nurse. And that, when she went back to school, was the first time through that school that she had health insurance. And she went into people's homes during COVID, taking care of COVID patients as a home healthcare nurse. And now, she's retired, and she and my stepdad, they live on Social Security, and it's not much based on her career as a greenhouse worker and then a home healthcare nurse. And, my stepdad, he uses a wheelchair. He's a double amputee because of health problems. And so when I saw that big bullshit bill that is cutting Medicare and Medicaid, I think immediately of my mom, still living in the house we grew up in, not a fancy log cabin, but, built through a model or by somebody else, but built with trees off of our land. And I think about everyone that I grew up with, who they're really struggling right now. And I think Trump appealed to some of those folks because they're so angry because they see people benefiting and they felt left out and left behind. And of course, ironically, all of the actions of the Trump administration is really going to further devastate their lives.
Yeah, that particular group of people, the American working families. And let me be clear, I think there's a little bit of a misconception that it is only targeting a specific wealth level or lack thereof. I mean, this really is just a billionaire boondoggle, in my opinion. But it's not just the blue collar families. I mean, it's a lot of people, inclusive of the middle class, that are going to be feeling this, if not already, with the increased prices. Why is it so important then? Because to your point, Maine is a small but independent state. Y'all have definitely made sure that you've made it clear that you guys walk your own path, walk to your own tune. But why is it so important then for you to take on this bigger role as the governor? Not to suggest it's necessarily higher, than the Secretary of State, because I think your job is actually critically important, especially these days. And we'll get to that in a minute when it comes to elections. But why continue in public service like this?
I think it is so important that we have strong leadership in this time. We have to fight back against the Trump administration. We have to see them in court. We have to challenge them at every moment. And I have the battle scars to prove it, that I can stand up and stand tough and fight for what is right, even when sometimes the outcomes look bleak. And then the other thing, and growing up in rural Maine, is we have to build some communities. We have to think creatively, like how are we going to provide healthcare to our people? Because in a place like Maine, where we have such a high percentage of people receiving Medicare and Medicaid, when those benefits are eviscerated, our rural hospitals are going to close. We're already seeing ERs and birthing centers close. So we're going to have to rethink how we do things. And so I think we need visionary leadership, tough leadership, and also the ability to fight for regular people, not for the oligarchs and the billionaires.
So tough but kind is a mantra that I actually teach to my 10-year-old daughter. And I've said, maybe people may come at me for this, but I've taught her too that sometimes you have to punch a bully back in the nose. But I do think that one of the critical examples as of late of you being tough and Maine tough is as the Secretary of State, the 50th Secretary of State for the state of Maine. Recently, the Department of Justice, and I think it's a disgusting name to call it the Civil Rights Division, because I don't think they actually respect civil rights anymore. But the voting section of the Civil Rights Division of the DOJ made a demand in July, at the end of July, for, in an unprecedented way, in my opinion, so much information and records concerning Maine voters. And I want my viewers to understand the following, because this is really important. Maine in 2024 was third in the nation in voter turnout, third in the entire United States. And in 2022, Maine was number one in the nation in voter turnout. More Maine citizens turned out to vote in 2024 than ever before in the history of the state. And as the Secretary of State, the elections is exclusively within your purview to have to maintain, to guarantee not only election integrity, but security. But they were asking for this sweeping scope of information and records, and you sent back the most comprehensive, polite yet scathing response on August 8th to the DOJ, wherein you let them know that you not only had grave concerns about the overbroad scope of the request, but that frankly, they're not giving you enough information to be able to comply because they don't give you the justifications. And you basically told them literally to go jump in the Gulf of Maine. I mean, Secretary Bellows, talk about why we need to continuously be paying attention to the threats that this administration is posing to things like election data, voter data.
So first and foremost, what this administration is doing is breaking all precedents, breaking the rules, and it's throwing the Constitution out the window. And we have to continue to say no. And it can be exhausting, right? Because it feels like every day is a new outrage, but we have to be firm. So when the Justice Department asked for the sensitive, personal voter information, not just of me and Maine voters, but every Secretary of State is getting this request, according to DOJ. And remember, in 2016, the Trump administration tried to do the same thing. And to a state, every state said no. And so I've got to confess, I borrowed the phrase, go jump in the Gulf of Maine. Right. But like literally, it's, they're hot under the collar. They're coming in, trying to get this data. The Gulf of Maine is awfully cold. Maybe they needed to cool down. But in 2016, a Republican Secretary of State, Delbert Hosemann of Mississippi, said to Trump, go jump in the Gulf of Mexico, back when we could call it the Gulf of Mexico, right?
It still is the Gulf of Mexico, let's be clear. Yeah, I get it.
And so every secretary stood strong. And now we're in this environment where people seem so afraid, so cowed, or so seeking their own political advantage, their own ambition, that we have some of these states are just jumping right in and saying, yes, please, how can we help you? Other states are feeling intimidated, feeling like perhaps they have to. But the Department of Justice doesn't get to have all of your information just because they want to. They have to have a good reason. And actually, federal privacy law has certain steps they're supposed to take before they're aggregating sensitive personal information of the citizenry. And also, just think for a moment, like, why do they want it? What is their reason? Because in the absence of a very good reason, you start to think, okay, well, how might they use it? And do we really want the Justice Department checking to see if you're a Democrat or a Republican before they make a decision about who to investigate for tax fraud or for another crime? I mean, the power of the federal government is significant. And so this idea that they're going to collect all of this information on everyone in the country is really out of bounds and very dangerous.
Well, they're also pushing the limits as well. We know Trump has tried to push an executive order concerning proof of citizenship, when frankly, the United States Constitution in and of itself says you can't vote unless you're a United States citizen. And there's already pre-existing penalties in that event. That's one aspect. But another one that I know that is very important to you and it's also been very important to me is the SAVE Act. The SAVE Act is facing debate in the United States Senate, but I know it's something that you've also been making sure that not only Maine voters are educated upon, but that frankly, all American voters understand what's at stake with the SAVE Act.
Yeah, so I run the Bureau of Motor Vehicles as Secretary of State. I'm one of the few that does. And we've been trying to modernize in a lot of different ways to make government work for the people, to make it more efficient. And we've had to implement Real ID that requires documentary proof of citizenship or legal status.
Yep.
There was a deadline in May where the federal government, Trump said, you can't get on a plane unless you have the Real ID. And we immediately saw waves of people coming into our BMV branches. And what we've noticed is the people that have the hardest time getting the Real ID are not naturalized citizens. Their documents are in order. They are usually all set. The people that have the most difficult time are senior citizens and married women. Senior citizens, because they're least likely to have a birth certificate. And in a place like Maine, right on the Canadian border, we have some senior citizens that were born in Canada. So we have an immigration attorney on staff at the BMV who I recruited to help with our new Mainers.
Oh, wow.
Oftentimes this immigration attorney is helping senior citizens in Maine prove their citizenship, even though they were born in Canada. These are folks that have served in wars, have been citizens their whole lives, but
Wow.
trying to prove that can be challenging. And then with married women, well, if your birth certificate says your maiden name, and if you're one of 85% of women who change their names when they marry, then the license or ID you're bringing to the BMV has a different name than your certified birth certificate. So then we need to see your marriage certificate. And if you've been married and divorced and married again, we may need to see all those chains of documentation. And for some women, to get that information, if they were married in another state or if they were divorced, maybe they got rid of their marriage certificate. They didn't want to think about it, but now they've got to track it down, and we need to see those official copies. So we've seen real problems with lots of citizens trying to get the real ID. And I can't even imagine on election day if suddenly our election clerks were saying to married women and senior citizens, I'm sorry, your documents aren't in order, you can't vote. But that's exactly what will happen. And there are other populations as well, our transgender Mainers, poor people. There are lots of populations that are going to have a harder time proving citizenship or be more subjected to discrimination.
Well, yeah, I mean, and the last kind of group of people is really important. It's expensive to do this, even though you try to keep the cost down as somebody like the Secretary of State, for example, just obtaining copies of records isn't necessarily that easy. I also think there's a whole kind of rural component of this as well. It's already been baked in terms of voter suppression to make it difficult where you have to vote in person, because now this whole Trump doesn't want the mail-in voting BS, right? I mean, we have all of that. But when you think about our rural voters as well, not only is there the geographic limitation, perhaps the transportation limitations, but frankly, it just disincentivizes you. If something's just more expensive and more difficult to do, what are you going to do? You're going to say, to hell with it. I'm not going to do it, which really creates baked in endemic problems when it comes to voting access.
100%. I think back to my childhood. There were times in our lives where we had one vehicle and my dad would take it to work. My mom would be home with us kids, or we'd be at school and she'd be at home. And then when he got home, she would go work nights. And they were working so hard just to make ends meet. The idea that, and budgets were so tight, I think for a lot of families, it's going to make voting out of reach. And then you pile on top of it this idea that Trump wants to ban mail-in voting, so you can't get your ballot and mail it back. That's absurd. It is completely out of touch with what people's lives are like, what people are going through on the ground. And the SAVE Act is an example of that too. It shows a disconnect between the oligarchs, the folks in Washington who, they have assistants, they have people in their lives that do this stuff for them, and people who are just trying to make a living, just trying to get by.
So let people know, Secretary Bellows, I know they know where to find you, but specifically if they're interested in helping you out as you run to be the next governor of Maine, where can they find more information and find ways to help you?
Bellows for Maine, and that's the great state of Maine, MAINE.com. So check us out online, follow us on social, and yes, we're a grassroots, people-powered campaign. I'm traveling all across the state and would love support. If we need courage in these perilous times. We need leaders who are going to stand up and fight back no matter what. And you said it earlier, kindness and toughness. We need both.
Yeah, and I loved what you also said, which is courage is contagious. I think I've been very clear. My view is we shouldn't judge others for their level of advocacy. Some people may not be comfortable going and protesting in a street. Some people may be more comfortable doing a postcard campaign. Either way, being engaged is how we make it. It's how we make it through what we're going through right now. We're incredibly dark times, but part of engagement also includes finding candidates like you that are still and continue to do exceptional jobs in public service, still delivering amazingly well for the people of Maine, but at the same time seeking to continue to give. I mean, you really are an example, Secretary Bellows, of what public service is. A lot of people would just pack their bags up and say, thanks, peace out, I've had enough. This is for the birds, but this is definitely not something for you. And so I'm really grateful that you took the time to not only, kind of go down that path of memory lane with me over that crazy kind of time, but also to let us know that there are people like you that are fighting, because we have to do this. I look at Gavin Newsom and I look at others, our Texas Democrats and the breaking quorum. And I'm in Florida. I'm a blue dot in a red state, but there are those of us that are preparing and steeling ourselves for a redistricting battle as well. I mean, there is a lot going on, but it's refreshing to know that you are already in a position of leadership and you're continuing forward. So I really appreciate that.
Thank you. And thank you for your leadership. You're creating a platform for important voices. You're a voice for those that don't have one. So let's just keep speaking out. We'll find the joy in each other and our communities, but also we have to fight back. We have to stand up.
Maine Secretary of State Shenna Bellows, thank you so much for being here. I've got in my hands here James Comey's motion and memorandum in support of motion to dismiss indictment, filed just yesterday in the Eastern District of Virginia. And lest you be concerned, yes, he's still pursuing the invalid appointment, the illegal appointment of Lindsay Halligan as the U.S. Attorney for the Eastern District of Virginia. That is also being chased down. But this is a really important motion that I wanted to run by and run through with you, because it raises substantive arguments concerning the grand jury indictment that was returned against him. Remember, it was 2 counts. We're going to walk through this motion together because it really boils down and summarizes what the government is alleging he has done illegally, improperly. And then it also summarizes in a great way why what he's done is not wrong at all, and why this indictment should be dismissed. So let's go through it. Let's walk through it. So count 1 seeks to punish Comey for responding to Ted Cruz's fundamentally ambiguous questions with literally true answers. And count 2 rests on allegedly those same false statements. But regardless, count 2 should be dismissed because Comey doesn't get adequate notice. And we're going to get into the specifics now. So let's fast forward to the introduction on page 5. And really, I'm going to walk through it with you because it really kind of gives you the lay of the land, as we call it. So here we go. Count 1 of the indictment seeks to punish Comey for seconds of testimony he gave in response to compound and ambiguous questioning. Literally seconds in hours of testimony. But longstanding principles of criminal law make it clear that the government cannot prove a violation of 18 U.S.C. 1001A2, right, which is the first charge against him, unless the government establishes that the defendant gave false answers to precise questions. And remember that, precise questions. Here, the indictment conspicuously omits the lengthy, confusing questions that prompted Mr. Comey's testimony. Specifically, after speaking for more than a minute, Senator Ted Cruz asked Comey to recall statements he had made 3 years earlier and to simultaneously address statements that Senator Cruz incorrectly claimed were made by Andrew McCabe, the former deputy director of the FBI. In doing so, Senator Cruz never indicated that he wanted Comey to address the statements or activities of any person except for McCabe. Viewed in that context, Senator Cruz's questions cannot form the basis for a violation of Section 1001A2 because they were fundamentally ambiguous. And regardless, Comey's answers to them were literally true. Count 2, dismissed for the same reasons, to the extent that count 2 rests on those same alleged false statements made by Comey. In addition, count 2 should be dismissed independently because Comey doesn't have any notice of the charges that are being brought against him for count 2. So here we go. Just to refresh your recollection, back in 2017 on May 3rd, James Comey voluntarily testified for hours at the Senate Judiciary Committee's hearing on annual oversight of the FBI. Okay, hours Comey testified, and he engaged in a back and forth with, at that time, Chuck Grassley. Okay, now you fast forward 3 years later on September 30th, 2020, more than 3 years, right? Comey again voluntarily appears, and I want to underscore for a second here the adverb voluntarily, right? Comey voluntarily testifying and appearing versus the horseshit we get from the Republicans who can't find their way to a congressional hearing, even if they're subpoenaed. But on September 30th of 2020, Comey voluntarily appeared before the Senate Judiciary Committee for a hearing on the Crossfire Hurricane investigation. Mr. Comey engaged in the following exchange with Senator Ted Cruz. And we're going to put up that exchange as it's excerpted here in the motion to dismiss, because I want to literally read it with you so you understand how absolutely absurd this exchange was with Ted Cruz. In fact, I'll do one better. We're going to play that exchange for you right now. Take a listen.
All right, let's shift to another topic. On May 3rd, 2017, in this committee, Chairman Grassley asked you point blank, quote, "Have you ever been an anonymous source in news reports about matters relating to the Trump investigation or the Clinton investigation?" You responded under oath, quote, "Never." He then asked you, quote, "Have you ever authorized someone else at the FBI to be an anonymous source in news reports about the Trump investigation or the Clinton administration?" You responded again under oath, "No." Now, as you know, Mr. McCabe, who works for you, has publicly and repeatedly stated that he leaked information to the Wall Street Journal and that you were directly aware of it and that you directly authorized it. Now, what Mr. McCabe is saying and what you testified to this committee cannot both be true. One or the other is false. Who's telling the truth?
I can only speak to my testimony. I stand by what the testimony you summarized that I gave in May of 2017.
So your testimony is you've never authorized anyone to leak. And Mr. McCabe, if he says contrary, is not telling the truth. Is that correct?
Again, I'm not going to characterize Andy's testimony, but mine is the same today.
I mean, what in the actual? Ted Cruz, of course, bloviating Cancun Cruz. He loves to hear himself speak. We know that about Ted Cruz. Did you know, though? Ted Cruz went to Harvard Law. Shit you not. And Ted Cruz served as the Solicitor General for the state of Texas, appointed by Governor Greg Abbott for years. So you would think Ted Cruz, with his legal training and experience, would know how to ask a damn question. Well, wouldn't it be funny if the way Ted Cruz asked James Comey questions back in 2020 turns up to blow the government's case up in Lindsay Halligan's face, substantively, because Cruz doesn't know how to ask a fucking question. I get my chuckles out of that, right? Okay, so based on that testimony, the government has charged James Comey with a 2-count indictment. So count 1 is making false statements to Congress. And in order to prove a false statements to Congress crime, the government must establish the following. 1, that Comey made a false statement to a governmental agency. 2, Comey acted knowingly or willfully. And 3, the false statement was material to a matter within the jurisdiction of the agency. And just because you maybe make allegations in an indictment that you present to a grand jury and it ticks off the elements of the crime, it does not mean that the crime has been proven, 1, beyond and to the exclusion of every reasonable doubt, which is the trial standard for a criminal case. Remember, it's a lower burden of proof for a federal prosecutor to get a grand jury indictment, right? It's just the probable cause standard. And so because of that, you could just say that this is what Comey did, but you mean to tell me that you think that any jury would understand what the hell Ted Cruz was asking back on 2020? Additionally, although the indictment does not specify that it was the exchange with Ted Cruz that is being the basis, that is forming the basis for this indictment in count 1, Comey's exchange with Ted Cruz is the only part of the 2017 Senate hearing that touched on whether Comey had authorized someone else at the FBI to be an anonymous source in a news report, which just goes to show that it really is that exchange by and between Comey, right? Count 2 charges James Comey with, quote, corruptly endeavoring to influence, obstruct, and impede a Senate Judiciary Committee investigation on or about the same date by making false and misleading statements before that committee. But the indictment doesn't specify what are the false and misleading statements. Think about this. You are federally indicted by the government. As a criminal defendant, you are legally entitled to know adequately, notice what you're being charged with. So, Lindsay Halligan, if she's doing such a bang-up fucking job, don't you think that she should be telling Comey with specificity, these are the exact false and misleading statements? She doesn't. The indictment doesn't have that. And because of this omission, not only can this indictment be dismissed, but let's just assume, because, Lindsay Halligan makes an ass out of you and me with that assumption. Let's just assume that it has to do with the Ted Cruz exchange. Well, on its face then, because of the same reasons that count 1 doesn't succeed, count 2 doesn't succeed. You gotta love this argument, and it's based in case law here. Fundamental to any false statement charge are both clear questions and false answers. Neither exists here. Seems pretty clear, right? I would tend to agree with that. Let's fast forward. And the motion really goes into in-depth detail, and we don't have to do it like super in-depth, but let's take a little bit of time though to talk about this, right? Because here's an interesting argument that James Comey raises in this motion to dismiss. Comey's literally true answers separately warrant a dismissal of count 1. So putting aside that there's total ambiguity in terms of Ted Cruz's shitty question to James Comey actually gave an honest answer, so that in and of itself cannot be a false statement that is made. That makes sense. Here it goes. Regardless of whether Senator Cruz's questions were fundamentally ambiguous, the court should also dismiss count 1 because Comey's answers were literally true. When a witness's answer is not responsive to the question asked, it cannot serve as the basis for a false statement's charge if it was literally true under any interpretation of the question. So consider this. Here, when Senator Cruz's preliminary statements are omitted from the questions and you kind of just get to what it seems like the 2 questions were that Cruz posed to James Comey, the first question was the following. Between James Comey and Andy McCabe, who's telling the truth? That's kind of the first question that Cruz teed up to Comey. And a direct answer to this question would have required Comey to respond either I'm telling the truth or Andy McCabe is telling the truth. But Comey didn't answer that way, right? He only said the following, quote, I can only speak to my testimony. I stand by the testimony you summarized that I gave in May of 2017. So although those statements by James Comey did not respond directly to Cruz's question, Comey's statements were literally true. Comey could only speak to his own testimony. He couldn't get into the mind or the brain of Andy McCabe and determine whether or not McCabe was lying and intentionally lying. So how is it that James Comey gave false statements to Congress? The same also applies to James Comey's answers to Ted Cruz's second question. Senator Cruz asked, quote, so your testimony is you've never authorized anyone to leak. And Mr. McCabe, if he says contrary, is not telling the truth. Is that correct? I mean, people, that was a literal quote I just said right there. And even I struggled to be able to say that because it doesn't make any actual sense. Right? And as for count 2, it's actually a much speedier argument, right? It's count 2 says Comey made false and misleading statements, but the indictment doesn't specify which false and misleading statements and which investigation he was endeavoring to corrupt. So count 2 doesn't have specificity. It renders it separately defective for failing to put Mr. Comey on notice as to the charges specifically that he is facing. And I like this argument from Comey's counsel because it just makes common sense. Quote, the government cannot try Mr. Comey on cherry-picked statements from a 4-hour hearing without specifying which statement it believes is false or misleading. And surely the government does not believe that it may secure an indictment based on one statement placed before the grand jury and then switch to a different statement at trial. That tactic would defeat the entire purpose of the grand jury performing its charging function. And I like this too. It also provides yet another reason for disclosure of the grand jury proceedings as Comey's concurrently filed motion to disclose grand jury proceedings requests. Let's stop a second there. Remember, grand jury proceedings are typically confidential, and there are very limited reasons, very exclusive limited reasons why a court would ever release grand jury proceedings. But in this instance, Comey wants those grand jury proceedings for a myriad of reasons. What the fuck did Lindsay Halligan tell these people to get this indictment? And then what the hell did she tell the grand jury was the basis for this indictment with the counts to be returned? goes further. And it's further basis to grant Mr. Comey's concurrently filed motion for bill of particulars as to this charge. Let's stop there. A motion for bill of particulars is what it sounds like. It's a motion that is being filed with the court that Comey has done saying, I need to have some particularity. I need to have some specificity because otherwise, how the hell am I supposed to prepare a defense to go to trial in January? By the way, I need to remind everybody this is set for trial in January. In January, if I don't really know the specifics about the charge that I'm facing. And then in conclusion, the indictment should be dismissed with prejudice. Amen. And we always go to the lawyers, right? Because we want to see the signature page. Like who's here? The signatory block, right? I want to highlight this. Pat Fitzgerald, we talked about. Huge fan. I'm a huge fan of his. Kicks ass. Amazing. Got some great lawyers here from Carmichael, Ellis, and Brock, and Cooley. But this name here, I've never discussed this with y'all. You might have heard it already. I just want to gently remind everybody here. Michael R. Dreeben. Ooh. You want to talk about bringing in the big guns? Pat Fitzgerald kicks ass 20 ways to Sunday, but you bring in Michael Dreeben and it changes the tenor of the game even more. It elevates the elegance, the power, and the oomph, the legal oomph of Comey's defense. Dreeben, you may recognize his name, former Deputy Solicitor General of the United States of America. He argued Trump versus the United States in front of the Supreme Court of the United States, argued against Trump having immunity. He was brought on as counselor to special counsel Jack Smith. If that wasn't impressive enough, Mr. Dreeben has argued 105 cases in front of the Supreme Court of the United States. People, just a little bit of some kind of professional insight. As a trial lawyer, which is what I have done for decades and which I continue to do, trial lawyers were pretty arrogant. We have an ego about the way that we know how to prepare a case and go to trial. But I will tell you, I try cases with somebody next to me. Always want second chair. You always, if you do have some humility as a trial lawyer, you don't want your ego to stand in the way of another set of ears, another set of eyes, another brain. About what's going on in the courtroom, about strategy, about pivoting. Paying attention to the little things. I also try cases with an appellate lawyer sitting next to me. A lawyer who knows the appeals process, who knows where the pitfalls are, where the quicksand is, and can make sure that they've got my six. When you have a trial team like Pat Fitzgerald and you have Michael Dreeben who can try cases in and of himself, but remember, a SCOTUS lawyer, though. Somebody who knows that law backwards and forwards, who knows what is precedent, who knows what is controlling law, that's a team to be reckoned with. These motions are going to be heard very quickly. They have to. It's the rocket docket, after all, in the Eastern District of Virginia. James Comey said on the eve of his indictment, or the evening of his indictment, he said, let's have a trial. He also said he still believes in our judicial system. My hat off to you, Mr. Comey, and to your impeccable legal team for this filing. It's damn good. Stay mad. Be outraged. Demand accountability. I'm off to rattle cases.